Welcome to Rampton Baseley's second webinar. Today we're talking about the Renters' Rights Bill. We're filming this in the 1840 in Wandsworth, so I want to say thank you to City and Country. So if you're looking for an amazing apartment in a brilliant scheme, talk to us about the 1840. It's a great place. I'm going to do a quick introduction to our panel. Firstly, I'm Joel Baseley. I'm one of the founders of Rampton Baseley. On my left, I've got Oliver Kenner from Quinta Law. And beyond Oliver, we've got Harry Evans, who heads up the lettings for Rampton Baseley. Quickly, if you wouldn't mind, Oliver, would you just explain a little bit about who you are and what your job is at Quinta?
Of course. I think the first thing to say is thank you, Joel, and for Harry for having me here. I'm one of the founding partners of Quinta Law. We're based in Farringdon, and my particular expertise is in property litigation. I've been a solicitor for 16 years now, and I do a lot of residential possession claims, 30 to 40 a year. So the new bill is going to significantly impact landlords, tenants, but also lawyers, because we're the ones who have to take possession when tenants haven't been particularly well behaved. So yeah, that's a bit about me.
Brilliant. Well, as I promised in all of the advertisements for this webinar, we're going to keep it as concise as possible. We're going to make sure it's really informative. It's a big subject, but what we've done is Harry has kindly sort of broken it down into 5 main sections. And they're the 5 main concerns that seem to keep cropping up with our clients. Today, this webinar is attended by lots of different people. There might be private landlords who are renting the properties themselves. It might be people that are using other agents, but it might be our own clients. It doesn't matter. But Harry's going to address or at least list those 5 elements. And then we're going to go through some questions that probably relate back to those 5 elements. And hopefully Oliver's going to be able to explain the answers to those. So Harry, would you mind talking us through these 5 things that people seem to be most worried about?
Yeah, sure. So like you said, it's a big bill with a lot of moving parts, but from speaking to our clients, you seem to be able to condense the core concerns into 5 key areas, like you said. So the first one is around tenancy structure. So with the end of fixed term contracts and the move to periodic agreements, and I guess people are concerned about what that's actually going to look like in practice. The second is around regaining possession. So with Section 21 being scrapped, landlords are understandably a bit concerned about what the new routes to possession are going to look like. Thirdly is rent review. So how rent increases are going to be handled and what safeguards are being put in place for tenants in that regard. Fourth is around advertising and competition. So obviously there's a clampdown on bidding wars going forward, and landlords are going to be required to advertise at a fixed asking price. So there are a few questions about that. And then lastly, I think is just around enforcement and resolution. You know, what mechanisms are being introduced to enforce these new rules, and also what are the consequences of them not being followed?
Okay, right. Well, look, let's jump straight in, and we'll put some of these questions that have been submitted to us forward to Oliver, and we'll see if those cover it off, but please expand as much as you feel necessary. So the first one comes in from Helen. She says, how will tenancy structures change under the bill?
Yep, that's a fair question, because it really is going to be a complete overhaul of the private renting system in England. I think it's important to start off by saying, what is the aim of the bill? Well, it's to give tenants more security and better standards of living, whilst trying to make landlords more accountable. I think if we're going back to the question about tenancy structure, it's going to be one of the biggest changes that the landlords are going to face when the bill is implemented. So right now, most landlords are familiar with the typical short hold tenancies. So if you've got a 6-month fixed term or a 12-month fixed term, or sometimes even longer. And within those tenancy agreements, you often find a tenant break clause or a landlord break clause, which allows either party or both to break a tenancy before the fixed term is ending. But importantly, that model is going to be scrapped. So once the bill is implemented, and at the moment we think that royal assent is going to be given in autumn this year, and it will be fully implemented sometime in early 2026, all agreements are going to be universally periodic, which is a big change. It completely scraps the fixed term system. But what does that mean in practice? Well, it means that every tenancy is going to roll month to month or period to period indefinitely. There will be no fixed terms, and break clauses will not exist. The period of the tenancy, or the rolling cycle, is going to be tied to the rent payment frequency. So if a tenant pays rent monthly, it will be a monthly periodic tenancy. And if a tenant pays rent weekly, it will be a weekly periodic tenancy. I think it's important to state that the bill will not capture every single tenancy. So for example, if you've got a tenancy to a company, that will fall outside of the regime. Again, if you've got a tenancy with a particularly high rent, so over £100,000, that will fall outside of the new regime, as will low rents. So that's £250 outside of London and £1,000 in London. Query how many of those tenancies actually exist, but they will fall outside, as will any holiday let agreements. So as the timings, this is very important. The government are introducing the bill in one go. They're calling it a big bang. So any agreement that is entered into post-implementation will be automatically periodic.
Yeah.
Crucially, and it's very important for landlords to understand this, that any existing tenancies that are in force at the time of the bill was implemented will automatically flip into the periodic status.
Right.
So it's so landlords can't just think, oh, it's okay, I've got an agreement and I've entered into it now and it's been going for a few years. No, if there's a break clause in that agreement, it will be valid and of no effect. So it will automatically flip from be voided from the dates of
Ollie,
implementation.
can I just ask a question on that? So because there are going to be some new rules around how much rent can be paid up front.
Yes,
is that right?
Correct. It can only be 1 month.
It can only be 1 month.
So for example, if it's rent's paid monthly, you can only accept 1 month up front.
Right.
The vast majority of the people that are on this webinar presumably will be taking their rent monthly, and it will fall within those remits, i.e. less than 100,000, more than £250. So this for 99% of the people, and 99% of our clients, it will be a periodic tenancy, basically.
Yeah, correct. And I think it's important to not to look at it from the landlord side, but what does it mean for tenants? It's actually very straightforward for tenants. They only have to give a 2-month notice if they wish to leave. So they can do that any time. So if a family moves in, let's say on the 1st of April 2026, provided the bill's been implemented, they could in theory serve a 2-month notice on the 2nd of April to expire in and around the 2nd of June, and they are free to leave. They don't need to give any reasons, they just serve their notice. And I can see how this is going to cause potentially some pretty big difficulties for landlords with cash flow predictability or void periods if they've got tenants turning up for 2 months and then having to find another tenant for, after 2 or 3 months. So I think the advice is really at this stage is communication is going to be key with tenants. Landlords should be on good terms, try and ascertain what is the intention of the tenants moving forward, because as I say, landlords don't want to be left with empty properties.
I think just from an agent's point of view, I should chip in there because a lot of estate agents will charge for their fees for the entire first term of their tenancy, so a year in advance, and their fees would come out that first month's rent. We don't do that. We take our fees monthly, but they're going to have to change the way they charge, aren't they? Presumably, I think all agents are going to end up having to charge monthly.
Correct.
Pay as you go, as it were.
That's right.
Okay, cool. Are we ready to move on to the next question? Do you think?
Yeah.
We covered that one.
Yeah, I think so.
Okay, so the second question. This one's from Peter. How will the bill affect my ability to regain possession of my property?
And it's a very fair question. You don't want to let your property to somebody and not be able to get possession. I think in the market, there's a lot of doom and gloom that landlords are sitting there thinking that they're not going to be able to get possession back. That's not right.
Yeah, it's not going to be like the old days of what were they called? Those sitting tenants.
Protected tenants who can sit there for years on end. No, that's not going to happen. But the crucial thing for landlords to understand is Section 21, which has really been the safety valve for landlords for years and years and years, is being abolished. So we all know that you can serve a 2-month notice. You don't need to give any grounds whatsoever, and the tenant must leave. And if you don't, you can then start your possession claim at court. That's going. So landlords moving forward are going to have to prove one of the specific grounds. They're going to be Section 8 grounds, and you have to give a valid reason. And you can't just say, "Oh, hold on, I want my property back," like you used to. So that's going to be a major, major change.
Is it worth just talking about what those reasons could be, or like the core reasons?
Yeah, I think so. So what I've done, I've tried to pick out 4 or 5 of the main grounds that I think are going to be relied upon moving forward, because there's about 37 if you break down all the subsections. And one of the key ones I imagine for landlords are going to be, well, what if my tenants don't pay rent? You don't want tenants being there and not paying.
Yeah.
There is a specific ground for that. So at the moment, if a tenant's more than 2 months in arrears, you can serve a 2-week notice and start your claim if they don't pay. That's being increased to 3 months. So a tenant has to be in arrears for more than 3 months if it's a monthly tenancy, or 13 weeks if it's going to be a weekly or fortnightly tenancy. And the notice period is going to change. So whereas before you could give 2 weeks notice, you now have to give 4 weeks notice. So that's quite a big
Can
change.
you only give the 4 weeks notice after the 3 months, or could you give the 4 weeks notice at the 2 months in order to finish at 3 months? Or do we
No,
not know that yet?
you have to wait until the tenant is in 3 months or more.
So you're looking at 4 months minimum,
Correct.
right?
So it's a big change. And I think notably, just worth mentioning that any universal credit payments that tenants receive aren't calculated into the...
I wonder if those landlord insurance policies are going to be more
Massively.
Yeah.
Yeah, massively. We've seen a
Important to our clients.
huge uptake in landlords
Have
just
we?
covering themselves. Yeah. I think you've got to in this it's such an affordable product that it seems like, not that I'm plugging rent insurance, but it just seems like a no-brainer with these new rules that are coming in.
I think that's right. I think it's also worth mentioning that there is going to be a specific round that targets repeated offenders. So if you've got people who have not paid for a number of years and there's certain time limits, you can rely on a specific round. Again, that's 2 week notice. So I think the key takeaway here is that if your tenant doesn't pay rent, there are things that you can do pretty quickly.
Okay.
So I thought that...
When you say repeat offenders, you talk about repeat offenders within the same tenancy or the same property.
Yeah. So
You've got the sort of national register of bad tenants.
no, it gets a little bit technical, but the law is stating that within a 3-year period, ending on the date you serve a notice, a tenant has to be more than 2 months in arrears for at least 1 day, 3 separate times. So it all gets a little bit tricky, but basically if a tenant doesn't pay or doesn't keep paying over a prolonged period, you can sort of whack that ground in and then start proceedings off the back of that.
Okay.
So that's the rent. And I picked out another one, which I think is going to be very important. I mean, a landlord may want to sell their property and they're going to be asking, well, how do I do that? So there's a specific round that caters for that. You can serve a notice, but you can't do so within the first 12 months of a tenancy.
Okay.
So if a tenancy gets introduced in April, you have to wait a full year before serving a notice.
Okay.
Which
I think that's kind of fair, isn't it?
it's kind of fair. It provides security for tenants, and landlords will just have to plan better. It's also a 4-month notice, so you can't serve it before the 12 months. So it ends up being 16 months. You've got somebody in there.
Right.
So it can't expire
No.
within the first 12.
No, so you can't serve it,
At month
say,
8.
month 8 for it to expire.
Yeah.
You have to wait the full 12 months.
Right. Okay.
And when you go to court, because that's another change, all possession claims are now going to be heard by the court rather than being dealt with on paper, which is going to cause a huge backlog. And I mean, I'm not sure the court will be able to handle it, but that's another topic. But yeah, you're going to have to go to court and prove your ground. So you're going to have prove a genuine intention to sell, marketing particulars and structure of an agent. And just to further complicate matters for landlords, there's going to be a protected period. So if you do get your possession order and tenant leaves, you can't re-let it for a period of 12 months. Okay. So it's really forcing landlords that if you're going to sell, you have to really want to sell and mean it.
What about moving back in yourself?
Yep, you can do that. And it's not just you, it's going to be a close family member. So siblings or partners or
Sons and daughters.
sons and daughters. Again, very similar to the ground I just discussed. It's you can't serve your notice until 12 months has elapsed. Again, a 4-month notice with the same restricted period. So again, it's planning.
And it's serving the notice. Presumably there is some sort of formal way that needs to be done.
Yes, there's going to be a statutory form. I would strongly suggest that landlords seek legal advice to do it properly, because it can be tricky, and you want to make sure that notice is valid, because the last thing you want to do is turn up at a court hearing 6 months, a year down the line, and a judge strike it out. So yeah, I would suggest speaking with solicitors and agents to ensure.
Yeah, presumably. I mean, a good professional estate agent will have a system for that.
100%. I mean, you don't always need to use solicitors. Reputable agents can often do that.
Well, we would be doing it on the advice of you guys, right?
Correct.
And we'll get a system going.
Correct, of course, because you have to deal with the deposits side of things as well.
Just on the protected period that you were talking about there, Ollie, I get a lot of questions about how that's going to be policed, and how, if a landlord tries to relet a property after, say, 4 months or within that time, what's the mechanism that's going to trigger that?
Well, the answer is nobody really knows at the moment, because it's still up in the air, but there's going to be a central database. It's going to be a national database for landlords. You have to register yourself as a landlord, and you have to put the details of every single tenancy on there. So I anticipate that if you try and relet it, it will pop up an alert who Who's actually going to monitor it, I don't know, but there are going to be some
Right.
pretty big fines, which we'll come on to later.
Yeah.
But as I say, it's going to be a big central database where all the information gets uploaded about landlords, their ability to rent, and also who they're letting to.
And they've already created that, have they? Presumably.
I'm not sure
that
exactly.
database.
It's not live.
That's the ombudsman. This is
No, there's two. So there's two databases landlords are going to have to sign up to, because over the past number of years, landlords can pretty much do what they want. They've now got to be part of this national landlord database and sign up as a member of the legal ombudsman, which is where tenants can make complaints. So, and also the database is going to be public or semi-public facing. So the tenants will be able to see some, if not all, of the information that's being uploaded. So there's going to be one big database. So it's much tighter regulation-wise for landlords than currently is.
Okay, so we've covered off if you want to do work to the property. Was that one of the things that we haven't discussed that, have we?
No,
we've discussed
tenancy structure.
Tenants not moving out, not paying their rent, or need to get them out because they're not paying the rent. We've covered wanting to sell the property. We've covered wanting to move back into the property.
I've just got a couple more that I think
go on.
that come up. So the good news for landlords is if a tenant misbehaves, so for example, sublets or causes damage to the property or carries out antisocial behaviour, throwing parties, and the police get involved, there is still a two-week notice that can be served.
Right.
So if you've got really bad tenants, there's something you can do pretty quick.
Okay.
So yeah, that doesn't.
You can serve that 2-week notice.
2-week notice
at any point.
So if I would suggest gathering evidence. So for example, if there's parties or drug use, you make a note of those.
Yeah.
And in your notice, you would have to say the grounds are antisocial behaviour and these are the reasons. So you can't just willy-nilly go and do it. But if a tenant's being really naughty, when they put in, 7 people you've never heard of, you should crack on and get your notice served quickly. Yeah.
Oh, that's good.
Yeah. So as I say, it's not all doom and gloom from a landlord side.
Okay, so the third question we've got here is from Jem with a J.
Hello, Jem.
Hello, Jem. Under the bill, what limits are placed on the landlord's ability to raise the rent, and what process must be followed?
Yeah, it's a great question. At the moment, if you've got during a fixed term tenancy, you can raise the rent if you've got a rent review clause in there. That's changing. So what landlords can do, you can raise the rent, but you can only do it once a year. And you must serve a statutory Section 13 notice, giving the tenant at least 2 months. And really important here, it has to be a fair market price, or fair market rent, I should say. The tenants here have quite an incentive to challenge that notice. So they can go off and say to the first tier tribunal, sorry, I think that's too high. And the tribunal will now make a determination as to what that fair market rent will be. They can't make it above the figure put in the landlord's notice, but they can certainly reduce it and keep it the same. And really crucially, it's not backdated to the date of the expiry of the notice. So commentary, we're thinking it's going to take 6 months for the tribunal to deal with these
I was going
applications.
to say, at least, can you imagine?
No, at least there's going to be thousands and thousands, because I see it as a free hit for tenants.
Yeah.
So they can just whack it in, and a tribunal is going to look at it. It could take 6 months, and it's not backdated. So I think the advice for landlords should be, it should speak to an agent when you're trying to do these notices, because what you want to do is put a rent that you think is the correct rent. There is no point sort of pumping for a rent that you're just not going to get, because it will be challenged. So as I say, there is a new route, a new statutory route, and you can only do it once a year.
Okay, right. Fourth question. Are there any requirements on how a landlord must market or advertise their rental properties under the bill? From Camilla.
Yes, so this is one of the big changes, and one that I think certainly will require agents' involvement, because there are several new marketing practices that are being stopped and need to be thought of. So the first and the big one is a ban on rent bidding. So when you advertise your property, you must advertise the clear and fixed rent. You can't invite or accept bids for a higher price than that. What the government's trying to do is try to relieve the pressure on tenants to create bids that they simply can't afford moving forward. So you have to be very, very clear how you market. It could be on Zoopla, Rightmove, Facebook, even in a shop window. You must give a clear and fixed price. There's no point saying the rent's £15,000 and then invite bids over and above that, because you will be penalised. So
but presumably you can, if the rent, let's say, is, we've advertised at £3,000, which is an ambitious price. Presumably the tenant can still come in and bid underneath that.
For sure. So I think landlords just need to set it at the price that they are happy with.
So all landlords are probably going to want a ambitious asking price, because
Correct.
That is the ceiling.
And you can see how that's going to increase the rent generally.
Yeah, this
which
is
probably doesn't resolve the issue that the government's trying to.
this is one of those brilliantly thought through things.
Yeah, exactly.
That is going to have the complete reverse effect of what they
Correct.
they're hoping for.
It's probably just going to price tenants out the market, and the stock will get lower and will become harder for everybody to rent. But there we go.
Yeah.
You also have to make sure that you're being fair and inclusive. So you can't go around with an advertisement saying, I don't want children, or I don't want people with housing benefits, because that's unlawful and you will likely face a fine.
I think pets come under that as well.
Yeah, so pets is one of the hot topics. So landlords can't just refuse an applicant because they don't like dogs or they're allergic to cats. You need to have a reasonable objection. So you can do that within a month or 28 days of an applicant asking for it. So for example, if the property is unsuitable, or there's some insurance restrictions, but yeah,
maybe you're not allowed pets under the terms of your lease.
Exactly, that's going to be one of the main reasons, because you can see how landlords would be in a complete pickle if they would have to allow Great Danes into a property that don't allow it. So,
and is it a bit like employment law where you're just not even allowed to ask those questions? Do you have children, for example?
Yeah.
Is that a thing? Does that stop?
I think you're in, and I think it ties into the legal ombudsman that's been created, where tenants are now free to go off and make a complaint. I think you're entitled to ask questions. You just can't discriminate on the basis of the answer. There's still ways of refusing applicants if you're not happy with them. So poor credit history, negative references. But ultimately, if someone's got a pet and you don't have a good reason, that dog's going to live in your property.
Right. Okay. Right. Interesting.
Would just on that, would discrimination count between offers then? So if that was the only offer on the table and a tenant had a dog, then assuming you'd have to accept it whether you liked it or not. But how would they prove, or how would discrimination be proved between two different offers?
Again, I think you would end up with a legal ombudsman claim, and they would look at what's been said and what the landlord's actually done. But I don't think you necessarily have to take on the sole applicant. As I say, if there are some insurance restrictions that said you can't have pets, or the head lease says that you can't, I would have thought that you can refuse that on that basis. But as I say, we really don't know how this is going to be policed. But on the face of it, yeah, pets are
on the menu.
Pets are
not literally, but
or not on the menu, as the case may be.
Okay, the last of the 5 questions. What happens if landlords don't follow these new rules? Are there sanctions? From Francesca.
Yes, so there are, and they're pretty hefty. They really been beefed up. So as I say, there's already those 2 schemes that you must join. And if you fall foul of joining a scheme, or you're accused of accepting bids that you're not supposed to, you can be faced with fines between £7,000 and potentially up to £40,000. Councils also have enhanced powers to make rent repayment orders, so you have to pay back the rent for a year, or ban you from the database, which would stop you from letting. So landlords are going to be much more heavily policed.
I think really, the big takeaway is there's just yet more compliance, isn't there? And you have to be, squeaky clean on the compliance, the way these things are served, and making sure that the process is properly followed.
100%. Landlords just can't think, oh, my property's fine and I don't need to do this. You do need to do it. So as you say, your landlord's processes and practices really have to be up to scratch. And document keeping has got to be fantastic.
We haven't even mentioned the licensing, the council licensing thing, and that's like a third part. So you've got to be a member of these 2 bodies, and you've got to make sure that you've got the correct license for your property.
It's correct. It's a minefield, selective licenses and the like, and also you have to make sure your deposits are protected correctly.
That's why you need a good agent, isn't it?
That's why you need a fantastic agent. But yeah, I think landlords are going to need assistance. Yeah. They're not going to be able to do this themselves, some of them, because they just don't have the time. And it's going to be complicated. And as I say, the sanctions are pretty severe.
But when you've got it sorted out, it's probably not going to be as scary as it might seem right now.
I think that's right. Everything seems scary before it's implemented, but once the bill kicks in and landlords and tenants get used to it, it'll become the norm.
Yeah.
But yeah, a good agent is certainly, because it's not just going to be a slap on the wrist. So you should have all your procedures in place, and especially when it comes to the marketing.
Good. Look, is there anything else that we haven't really covered, do you think, in this chat? Is there anything we need to add?
I don't think so. I think, like you said, there's so much to go through, and like Oliver said, there's so many different parts of every different facet of this bill that you could talk about it for hours. And I think if people have questions after this, they can pick up the phone and happy to talk through anything else that we haven't covered.
Yeah, absolutely. I mean, get in touch with Harry. I mean, Harry may well be getting in touch with you to see if we covered off everything that you wanted to know about anyway. But really, I think we'll bring it to a close. I did say it would be concise and informative. Hopefully it's been both of those things. Thanks for joining us. Thanks to our little panel here, particularly Oliver. Thank you very much.
Thanks, Joel.
And Quinta Law. They're the people you need to speak to in all matters property related. Thanks, guys. We'll see you at the next one.